Hi everybody. So today I'm going to talk about Bill C-6, or also known as the changes to the Canadian Citizenship Act. And what better place to talk about this subject than the Parliament of Canada here in Ottawa, where this bill was discussed, it was approved, received royal assent from the Governor General, which is the representative of the Queen in Canada, and became law. Right? So Bill C-6 was approved and received royal assent in June of 2017, and these changes have been introduced in stages, came into effect in stages. So some of these provisions in this Bill C-6 came into effect immediately after the bill received royal assent in June. Others came into effect more recently in October 2017, October 11. And two provisions of Bill C-6 will come into effect next year in early 2018. So let's go by order and discuss how things were before and what are the changes of Bill C-6. Right? So first of all, and I have here my trusty notes because it's a lot of changes. So under the previous Citizenship Act, citizenship could be revoked from dual citizens who were convicted of certain types of crimes like treason, spying, terrorism, and this provision was repealed under Bill C-6. So dual citizens living in Canada who are convicted of these types of crimes will not have their citizenship taken away. They will just face the Canadian justice system like any other Canadian-born citizen would. Right? It's a controversial measure. Some people agree, some people disagree. Let me know what you think in the comment section below. So next, before people want to apply for Canadian citizenship were required to demonstrate that they intended to continue to live in Canada after granted Canadian citizenship, right? And this provision under Bill C-6 was repealed, so applicants are no longer required to demonstrate that they want to continue to live in Canada after they granted Canadian citizenship. So this gives more flexibility for Canadians who need to live and work abroad for either personal reasons, work reasons, and it makes things more fair, actually, because Canadian-born citizens don't have to give any justification, any explanation to the Canadian government if they wanted to live or work abroad, right? So having this requirement from people who wanted to become Canadian citizens created two different classes, two different tiers of citizenship, right? And that was really unfair. So now everyone is on the same level of field. Right, next, in the previous Citizenship Act, the Minister of Immigration had the discretion to waive certain requirements under the subsection 5.1 of the Citizenship Act to grant Canadian citizenship to a minor without a Canadian parent, right? It was a discretion of the Minister of Immigration to either waive or not waive those requirements. Now, all minors can now apply for citizenship without a Canadian parent, as the age requirement for citizenship has been removed. And so a person having a custody of a minor or empowered to act on their behalf under court order, for instance, now can apply for citizenship of the minor on behalf of the minor, of course, unless the requirement is waived by the minister. Right. Also, before, there was no provision on the Citizenship Act to prevent a permanent resident who was in Canada serving a community service or a conditional sentence, probation. Nothing prevented under the Citizenship Act that person from doing that period of the conditional sentence or probation, community service, from being granted Canadian citizenship or taking the oath of citizenship, right? Or even just counting that period of time of the conditional sentence towards the citizenship requirements, right? Now, what Bill C-6 did is that now individuals serving a conditional sentence will not be granted citizenship, will not take the oath of citizenship, we're not going to be able to count this conditional sentence period towards meeting the physical presence requirements for citizenship. Okay. Also, before, the minister added discretion to grant citizenship to a person to alleviate cases of special and undue hardship or to reward services of exceptional value to Canada. With Bill C-6, this still exists, but they just added another factor, another ground that people, an argument that people would be able to request Canadian citizenship under this special exception. And that ground is statelessness. So a person without stateless person who has no state, no citizenship. Now this has been added, statelessness has been added as standalone ground that can be considered for a discretionary grant of citizenship. So that doesn't mean that everyone who is stateless will be granted Canadian citizenship, of course, but they can apply for it and they can present their case to the Minister of Immigration and request to be granted a Canadian citizenship, at the discretion of the Minister of Immigration, based on that fact, right? Also, until now, there was nothing on the Canadian Citizenship Act that about accommodating the needs of citizenship applicants who had a disability or who had a special need, for instance, of deaf applicants who needed an interpreter during a citizenship test or an interview with a citizenship judge or citizenship officer, or blind applicants who needed to do an oral test, an oral citizenship test instead of a written one. Those sort of situations, right? And now there is Bill C-6 introduced, explicitly written on the Citizenship Act, this requirement to take into consideration reasonable measures to be taken to accommodate the needs of certain citizenship applicants who have a disability or who have any special needs. Okay, and the last of those provisions from Bill C-6 that were introduced in June refers to the requirements that citizenship applications received on or after June 11 of 2015, those applicants had to maintain the requirements for citizenship since the application is submitted until they take the oath of citizenship, which right now takes about a year for a citizenship application to be completed, to be processed, and they had to meet those requirements. Applications received before June 11, 2015 didn't have this requirement of maintaining eligibility for citizenship during the entire process. With Bill C-6, this requirement now applies to everyone, to all applications, including those that were received before June 11 of 2015. Okay. So this was the changes that happened and took effect in June of 2017. So when this bill received royal assent. And now let's talk about the changes that took effect in October 2017, so more recently. First is a big one, has to do with the physical presence requirements in Canada, and this is something that a lot of people were really waiting for this change to happen, for this to come into effect, because this allowed a lot of people who weren't eligible for Canadian citizenship yet to now become eligible to apply for Canadian citizenship right now, myself included. So before, under the previous Citizenship Act, applicants had to be physically present in Canada for 4 out of the past 6 years prior to the application. That time of this physical presence in Canada requirement was reduced from 4 out of 6 to 3 out of 5. So now applicants are required to only be physically present in Canada for 3 out of the past 5 years before applying for citizenship. So people who are already in Canada for 3 years and they had to wait another year to apply for citizenship. Now, due to this change, now they are eligible to apply for Canadian citizenship right now. So, that includes me. That doesn't mean I'm going to apply for Canadian citizenship, but it's doesn't mean that I want to apply for Canadian citizenship, but it's good to have the options open. Just a lot of people were glad that this change was introduced, which, by the way, this was one of the promises by Justin Trudeau. So it's good to see promises being kept, right? And in politicians going through with what they promised, right? So another requirement that before applicants were required to provide evidence that they filed taxes, Canadian income taxes, for last 4 out of 6 years prior to the application, right? This was before. Now applicants must still provide evidence that they filed taxes in Canada, but for 3 out of the past 5 years instead of 4 out of 6. So just to match this physical presence requirements, right? In addition to the physical presence requirements to become eligible for Canadian citizenship being in years, there was also requirements in the minimum number of days that applicants had to spend in Canada to be physically present in Canada, which was a minimum 183 days per year out of the 4 out of 6 years prior to the application. But this provision was repealed altogether. No one insists with Bill C-6, so applicants are no longer required to have to meet these requirements of being physically present in Canada for at least 183 days per year out of the each year prior to the application. Another one that was also introduced recently in October, and it's also a big one that also helped a lot of people to become eligible for Canadian citizenship that's otherwise they wouldn't, is that refers to the time spent in Canada before, the time spent in Canada prior to become a permanent resident didn't count absolutely nothing towards meeting the physical presence requirements to apply for citizenship. So what this means is that the clock only starts ticking in terms of meeting the citizenship requirements. The clock only starts ticking the moment a person became a permanent resident, right? On day one, that person became a permanent resident. So people who were in Canada before Canada legally, before becoming a permanent resident, a lot of people come to Canada first on their work permit or a study permit, and then they apply and obtain permanent residence, right? So all that time spent in Canada on a work permit or a study permit didn't count absolutely nothing towards the citizenship requirements, right? So what Bill C-6 brought is that now applicants may count each day that they passed on a work permit or study permit, each day that they passed as a temporary resident in Canada prior to becoming permanent residents. Each day counts as a half day towards meeting the physical presence requirement for citizenship, up to a maximum of 365 days, so up to a maximum of 1 year. So what this means is that, let's say that, for instance, myself, I'm going to give my own example on this. Before I became a permanent resident, I was already in Canada on a 2-year work permit. So with this Bill C-6, I can get a 1-year credit for those 2 years on a work permit. I can get 1-year credit towards meeting this 3 out of 5 years to become eligible for Canadian citizenship. Right? The same would happen. People who were in Canada on a study permit, right? A lot of people are in Canada study permits and apply for a postgraduate work permit, and then apply and become permanent residents. So they can count out of those years in Canada as a temporary resident. Each day counts as a half day. Get a credit of half day towards the eligibility for citizenship, right? Up to a maximum of 1 year, right? So, like I said, 2-year work permits before a person became permanent resident counts. A person can claim 1 year, which means that the person would need to only be a permanent resident for 2 years, plus that 1 year credit of time spent before obtaining permanent residence, and then already would be able to apply for Canadian citizenship. I hope that people understood this. Okay, of course that this only applies to legal work, so to work permits, study permits. So the other day people asked me about people who are undocumented, who came to Canada as visitors and stay in Canada for the last couple of years illegally, without status, without the proper documents, right? Unfortunately, because the person was here illegally, so they can't demonstrate that they actually were here because they weren't supposed to be here without status. So unfortunately, that doesn't count towards the citizenship requirement, right? So which means that in those cases, people need to fix their situation and obtain legal status, and then go from there, right? Lots of papers. Okay, and the last of the provisions that were introduced in October have to do with who can and can't, who has or doesn't have to take the citizenship test and provide language proficiency tests in either English or French, Canada's official languages, right? So before, applicants who were between the age of 14 and 64 had to take the citizenship test and had to provide an evidence of meet the language and knowledge requirements for citizenship, right? So an English or French test and citizenship test. For people who were in Canada, or for applicants that were between the ages of 14 and 64. Now that time was those limits were changed. So now applicants between the ages of 18 and 54 are the only ones who need to meet the language and knowledge requirements for citizenship. So the ones who need to do an English or French test for citizenship for citizenship application, and to do a citizenship test, right? This is to allow because, like the minister said, it was not fair that 14-year-olds who already have to worry about studying for their school, for their exams, also had to study for an English or French test, or so had to study for a citizenship test, right? So that's why they put, instead of 14, they put 18-year-olds. And also elderly people after the age of 54 don't need to provide those requirements, right? So these were the changes that were introduced from Bill C-6 that took effect right now in October. Now I'm going to talk, and just to finish this video off, I'm going to talk about the changes that are going to take effect, is on the Bill C-6, right, on the Citizenship Act. They're going to take effect in early 2018. There are two. So under the previous Citizenship Act, the Minister of Immigration was the decision maker to revoke, to take away citizenship to applicants on the grounds of misrepresentation, fraud, concealing material circumstances. And the federal court at the time, under the previous Citizenship Act, the federal court was the decision maker for citizenship revocation in cases that involve also fraud, false representation, but or concealing material circumstances, but related specifically to human and international rights violations, security, organized criminality, right? With Bill C-6, the federal court will be the decision making in all revocation cases, citizenship revocation cases, unless the individual requests that the minister make the decision, right? So now by default, before there was split, the Minister of Immigration was a decision maker to take citizenship away for certain cases of fraud and federal court on other types of cases, right? Now the federal court is by default the decision maker on all citizenship revocation cases, unless the individual involved in this situation, this process, makes the decision that the Minister of Immigration would be the decision maker, right? And last but not least, under the previous Citizenship Act, there was no clear authority for citizenship officers to seize fraudulent or suspected fraudulent documents provided under the Citizenship Act. So before, if citizenship officers saw a document that they suspected they were fake, or that they knew and they have evidence that that document was fake, document on our application for citizenship, the citizenship officers couldn't seize that document as evidence for their decision, right? But now exists under the Citizenship Act. Now is clear authority written specifically on the Citizenship Act that citizenship officers can seize fraudulent or suspected fraudulent documents provided on people's applications, right? So these are all the changes that the Bill C-6 is brought already, and is bringing also in early 2018. Let me know what you think, and do you agree, do you disagree, are you happy, did you become eligible to apply for Canadian citizenship due to these changes? Just let us know, and just let us know in the comments, and I'll see you guys in my next video.